have motions to sever filed by Isaiah Chance, Sean Gathright, and Rashad Murphy, correct?
Yes, Judge.
And I did not, was there one filed by Davion Murphy, a separate one, or did you all just incorporate all of the other motions?
Because we would adopt the motion to sever as well,
Okay.
but I did not file a separate motion.
Okay, very good.
That is correct, Your Honor.
Okay. Yes.
Judge, would the court allow us to be heard, or do you think it's prudent for us to be heard just briefly on scheduling?
Sure. Yeah.
Judge, I truly appreciate Ms. Doherty's ability to corral all of these things and provide us with an anticipated schedule. There are just a couple of things that I wanted to bring to the court's attention for your consideration. And that is that there appear to be, in addition to the motions for severance today, some other motions that might have some anticipatory ability to be heard. And as it relates to number 5, which is the state's motion in limine for pretrial ruling regarding admissibility of evidence. It's set forth in Mr. Gathright's style, but I think that it dovetails and it has application potentially to other defendants. And when I look at the additional schedule, the court is going to note that, again, pursuant to the schedule, Rashad Murphy, which would have been Friday morning, but now won't be Friday morning, number 10, is a motion in limine and a Daubert challenge, opinion testimony regarding gang war, hearsay-based gang intelligence, and uncharged and unsolved acts of violence. I believe that those two motions should be heard in conjunction with each other. I think it makes a whole lot of sense from a redundancy standpoint and a thoroughness standpoint. So I would be suggesting to the court that if we do get to other motions today, that it not be number 5, and that either, unless the state has a particular objection or wants to be heard on it, that whenever we now get to when the next time frame will be after Friday for motion number 10, that we hear motion number 5 at that time. So that is my first observation or request. The second might be that, as the court is aware, my second phase counsel was not able to be here today, will not be able to be here tomorrow. Tomorrow, if everything goes as the schedule might anticipate, it appears that in the afternoon, there would be all of the state's penalty phase motions in limine, as well as all of the other second phase motions.
Right.
An abundance of them, although we all know that those normally don't take hours and hours and hours worth of argument. But bringing it to the court's attention that Mr. Hernandez will not be here tomorrow, I can tell the court I'm certainly not prepared and not in a position with my other obligations to argue the Rashad Murphy penalty phase motions, and whether or not either Mr. Hernandez can do those separately at a time available to the court.
Well, I think we already set Tuesday.
Okay, and that's, again, presuming the schedule, flows, and obviously we don't have Friday as well. Also, the one thing I would ask the court, if tomorrow we do get to the state's motions in limine, that Mr. Hernandez be able to, although the motions might have already been heard, be able to add or argue as it relates to those motions in limine separately at the time set for Mr. Murphy's second phase motions.
Okay. Right. So I hear you. I think that makes sense as far as scheduling goes. So my plan is today to hear the motions to sever and at least begin to discuss the parameters of the gang evidence and how much of it is coming in, if any. And then what I was going to have you all do on Friday, since we don't have court, was get together and see if what you're in agreement on the penalty phase motion. So my experience with the penalty phase motions, oftentimes there's a fair amount of agreement between the state and the defense, and then that way we can really streamline what penalty phase motions really need to be litigated. Okay?
I'll pass that on to Mr. Hernandez, Judge.
Yes. So that would be as to all the defendants, just to get with the state and see what you all can agree upon, and then whatever cannot be agreed upon, I will hear Tuesday. All right? Okay, so, as I indicated, there are the three motions. Do you all have any preference in light of Mr. Sonardi's, even though he doesn't have a motion per se, apparently he's adopted yours, Mr. Gonzalez, correct?
That is correct, Ron.
Okay, so do you want to go first?
Judge, without objection from co-counsel, it probably would be appropriate for me to go first.
Any objection? Okay,
No, Your Honor.
okay, very good. You may proceed.
Judge, what I anticipate doing this afternoon with the court's approval is, I'm going to argue my motion for severance or in the alternative, and then I would ask the court to allow me to hear the state's response and arguments to the motion, then allowing me rebuttal.
Sure.
And so to that extent, Judge, essentially, we have filed, and certainly I think this motion dovetails with other co-defendants in many respects, a motion for severance. The state has listed as inextricably intertwined evidence that, in my mind, is neither directly or indirectly tied to Mr. Murphy. To the contrary, it seems that this is a documentary of a large amount of pre-act evidence that utilizes a lot of inference in order to be called purported evidentiary connections. Essentially, the state's introducing and linking co-defendants to prior bad acts in support of a group narrative theory. The prejudice that requires severance in this case doesn't really arise from a single evidentiary issue. It's more from a cumulative effect of multiple categories of evidence, which I will bring to the court's attention. And certainly the state's theory of guilt depends on presenting these categories as a collective proof of an ongoing gang war, inviting the jury to infer intent, motive, and participation by association rather than by individualized proof as to each defendant in and of themselves. Specifically, I think the state's going to rely on 5 essentially different types of evidence. Violence linking co-defendants, Mr. Gathright and Mr. Chance, to a prior attempt on Julio Foolio's life. A large volume of physical evidence that links, again, Mr. Gathright and Mr. Chance, but not to the defendant. Pre-conspiracy and post-offense statements that are linked to Mr. Chance, and also as it relates to the prior attempted murder. Celebratory statements that occur post-murder that are allegedly made by Davion Murphy, and at one time attributed to Mr. Rashad Murphy, and then an extensive amount of gang-affiliated evidence that materially differs in scope and reliability and probative value as it relates to Mr. Chance and Mr. Murphy. I believe that there's a substantial risk that the jury will render a decision in this case and not be able to contextualize these inferences as it relates to that individualized proof. And I want to go over the types of evidence that I anticipate the state attempting to introduce. I'm going to dispense with a factual basis of the case. The court's well aware of the factual basis, although I will suggest to the court that the conspiratory time frame in this case is June 21st of 2024 through June 23rd of 2024.
And that's what's alleged in the indictment, correct?
Yes, Judge. I don't believe that there's any evidentiary link of any tie to establish any relationship between Ms. Andrews and Mr. Murphy, or Mr. Murphy and Mr. Chance, except in happenstance type circumstances. We're talking about historically.
Right.
First of all, Judge, there's evidence, as we talked about, of prior acts. And the motive, obviously, as the court's aware, is an ongoing gang war between two rival gangs, ATK and 1200 as one group per se, and 6 Block. The allegation is that the defendant, Mr. Murphy, is affiliated with 1200. Co-defendant Chance is affiliated with ATK. Co-defendant Davion Murphy is associated with ATK/1200, and that the victim is affiliated with 6 Block. To establish the nature of that gang war, the state intends to introduce a large volume of evidence that relates to a number of prior shootings and prior killings, most of which are unsolved, and none of which relate to the defendant. 2 of those particular prior acts are the October 6, 2023 murder of Antonio Tilley and the attempted murder of Foolio on October 7th. It would be my contention that there's no evidentiary link between Tilley's murder and Foolio's attempted murder, that the state intends to introduce testimony and argument that Foolio was shot in retaliation for Tilley's murder. It's anticipated that the state will utilize multiple detectives who they will suggest to the court and to the jury are experts regarding that both Mr. Gathright and Mr. Chance are suspects in Foolio's attempted murder of October 7th, 2023. The defendant had no relationship to Tilley or to Foolio for that matter, and there's no evidence that he was connected to either of those crimes or either of those offenses. And they are, in fact, especially Foolio's murder, attempted murder, unsolved to that extent. While Tilley was shot by Jacon Mills and another unnamed co-conspirator on the 6th of October 2023, he had been flagged as a member of ATK, and Jaquan Mills was not affiliated or documented in a gang. Law enforcement believes, and this is pursuant, everything I tell the court is pursuant to sworn testimony, which I've supplied to the court in the form of depositions at length of every one of these detectives.
I have them.
And to the extent that law enforcement in that sworn testimony believed that Tilley's death was a contract killing. And however, those underlying circumstances regarding those who are responsible are apparently still under investigation and are largely speculative. Again, Foolio's murder, attempted murder, is unsolved. To establish a link and to support the theory regarding the motive, the state intends to introduce evidence related to Chance and Gathright. During the investigation, there are forensic findings that law enforcement became aware of regarding the attempted murder of Foolio in October of 2023. In June of 2024, there was a search of Mr. Gathwright's vehicle wherein there were casings recovered from the scene of Foolio's attempted murder, presumptively matched to that firearm. There are communications between Mr. Chance and Ms. Andrews that the court is aware of regarding or allegedly regarding this particular murder. And essentially, in general, Chance tells Andrews that he needed to lay low for a while and asks Andrews to stay loyal. That is obviously part of the provided discovery and also Detective Ramos's sworn testimony and deposition. There are additional communications that the state intends to enter with regard to Mr. Chance's alleged involvement in other Jacksonville murders as well. The state also intends to introduce statements purportedly made by Mr. Chance in reference to his involvement in a prior attempted murder on Julio Foolio. And weeks prior to that charged homicide, and 8 months after Foolio was shot in 2023, Mr. Chance appeared in a video conversation over Twitter or X, where he makes statements to Foolio that, is your foot okay, and he has bigger fish to fry. Again, Judge, as I lay this out for the court, I'm not suggesting that, one, we can't get beyond, two, we can't get beyond. It's a cumulative effect and how it is compartmentalized as to individual defendants as opposed to degree. I want to say at this juncture, too, that I'm talking about these things, and I'm going to argue this more after the state argues. This is a motion for severance. This is not a motion for inadmissible or admissibility of evidence. We have motions for that.
Right.
The court's going to hear that. Severance is a different ballgame, and severance is determined under different rules and under different law. And so I just make that point as I go through this, because I don't want the court to be bogged down simply because I'm talking about facts. I think contextually I need to give the court a full understanding, not only for the court, because I recognize it's a little different for you, because you have been exposed to some of this already in a prior proceeding. But as it relates to the overall posture, you also were not privy to other parts of it that we're going to talk about today. And again, these shootings are unsolved. So in an attempt, again, to establish a connection between Mr. Murphy and Mr. Chance and the October 23rd shooting, which again is almost a year from Foolio's murder, and certainly far beyond the conspiratorial framework, the state also is going to rely on an Instagram message or an Instagram conversation where Mr. Chance says, had to switch it up, coming different in 2024, love you, brother. And it looks like Tilly and a ghost 187 underscore are tagged. I hope I'm using the right words, because one thing I can tell the court, I am technologically not savvy, and I don't own social media of any kind. So
Well, we speak the same language,
bear
Mr. Gonzalez.
bear with
so-
me if I'm not using the right terminology. So in taking the deposition of Detective Nieder, his interpretation of this statement is Chance got upset with ATK and told them that they didn't get a get back for Tilly's murder, so he's switching up the family, and then he tags what Detective Nieder believes is Rashad Murphy's Instagram account, which that's another, okay? That is Detective Nieder's interpretation of that Instagram communication. So he doesn't say that this is based on any kind of coded language that is known. It's simply his own translation of this particular statement.
So, Mr. Gonzalez, it'll help me, as far as just doing the analysis on this, is to ask you this specific question, first of all. Obviously, if there's a Bruton problem.
There's not.
Okay, I just wanted to make sure we had gotten that.
There's
So-
no antagonistic defenses,
Okay.
there's no Bruton problem. That's
Okay.
not what, the state spends a lot of time talking about those things in their
Right.
response. And I'll certainly hear them out. Those are not the issues. This is evidence admissible as to one defendant that is inadmissible to another.
Okay, I just wanted to make sure that there was no allegation of a Bruton issue, so instead it would be the fallback that, so Brutons are obviously, there's a Bruton problem, obviously there should be a severance. So then the next question would be, is whether severance should be granted, and this has to be based on a case-by-case basis.
Absolutely.
So you're going under the second prong, basically, of a severance. severance.
Yes,
There is no
Judge.
Bruton, but based upon the totality of all the evidence, there should be a severance granted.
That's correct, Judge. I'm going to talk
Okay.
about that a little bit more in the rebuttal.
Okay.
But you are correct. So next, Judge, category, if you will, is going to be physical evidence that is admissible against particular defendants, but absolutely not admissible against Mr. Murphy. Now, we're going to hear, inextricably intertwined, we're going to hear a motive, okay? But at the end of the day, as it relates to severance, okay, on June 26th, a search was conducted of Mr. Gathwright's vehicle, and in that vehicle were a litany of an arsenal, okay, of firearms, of ammunition, of switches, of rifle magazines, rifle stocks, buttocks, pistol holders, all of those things. The state would like to admit that, and the state would like that not to spill over and trickle down to Mr. Murphy. So they also would like to suggest that a cell phone that was found there was a straight talk throwaway phone that Mr. Gathright is now using because he got rid of his phone that was used during the course of the murder. So we're developing the arguments that are going to be put forth with regard to this evidence if admitted. And I know there's also motions pending, are going to be motions pending on these issues as it relates specifically to Mr. Gathright. Now, understanding that the court's ruling on that, obviously, is very important as it relates to all the defendants, and in my particular case, Mr. Murphy. So, in paragraph 15, the state intends to introduce evidence linking Gathright also to the attempted murder based on shell casings that were found from that vehicle. So, shell casings from the attempted murder of Foolio, okay, found in Gathwright's car, are going to be used to attempt to implicate Mr. Murphy. Because it's inextricably intertwined? No. Because it's motive? No. Because that is evidence against Mr. Gathright. And in a joint trial, okay, that cannot come in against Mr. Murphy. So, moving on,
So your position is that the physical evidence found in Mr. Gathwright's, either his car or his home, would not be admissible in a trial against your client, even though they are both charged as part of a conspiracy. Is that what you're telling me?
no, Judge. No, Judge. And
So
again,
that's, yes, you agree with me, your
I-
argument is,
that is my argument.
Okay, all right.
That is my argument. And first of all, again, the murder's over. The conspiratorial time frame is done. Can't come in under conspiracy theory.
well, no statements could come in, but you're saying the physical evidence couldn't come in either?
Nope.
Okay. Do you have case law that says that?
Judge, I will.
It's okay, don't do it now, I don't want to interrupt you, just,
know, but I want to write down.
yeah, just make a note. I'm aware of the case law regarding co-conspirator statements are inadmissible once the conspiracy is finished. Those don't come in post-conspiracy concluding, but the physical evidence not coming in is a different argument.
Judge, additionally, there are also casings found at that time that are tied to another homicide in May that occurred in proximity to the residence frequented by Mr. Chance. Again, this is evidence I expect the state to attempt to introduce. There is no evidentiary connection between those prior incidents, that prior offense, and as it relates to the prior attempted murder of Mr. Foolio, that is related to the defendant. None of the evidence that is seized from Gathwright's vehicle is connected to the charged offense. Okay? That's particularly of note for the court. Likewise, none of the evidence is connected to Mr. Murphy in any way, shape, or form. moving on, again, the court knows that Mr. Gathright also had his residence, a search warrant done on his residence, and again, a large amount of firearms and ammunitions were found, 2 AR-style rifles, which are equipped with brass catchers and spent 9mm casings. There's no forensic link between the rifles and the charged offense, and there's no connection of those firearms to Mr. Murphy. The 9mm casings matched casings that were found from the homicide scene. Law enforcement originally thought that they were fired from the same firearm, but after further analysis, they determined, or they thought, that the same firearm was used, but at a different time. So they were able to count up the number of casings and determined that although they were a match, that casing was not used in the homicide. It must have been, the casing must have been, become from another usage, okay? So because they were able to find all of the 9mm that would fill the magazine at the scene, which means anything that they would have found in Mr. Gathright's home was not going to be connected to the murder scene. So that's an important fact, but they want to get it in anyway. And I believe, based on Detective Ramos's deposition, that's exactly what he's going to say. At the same time, Judge, there were search warrants done on Mr. Chance's residence, a 9mm Glock with an extended magazine, boxes of firearms, talking about switches in a notebook, and of course, a switch meaning something that makes a semi-automatic an automatic weapon, even if it's not built that way. A poster of what's called Bully Down that was that was made by somebody, but in Mr. Chance's room, and essentially would be speculated on by Jacksonville detectives that is a perceived sign of disrespect to Julio Foolio. None of the evidence in Mr. Chance's residence had any evidentiary connection to the charged offense. To the extent that the state argues that the poster supports this underlying motive theory, the poster has no evidentiary involvement or connection to Rashad Murphy. Next category, Judge, of evidence is post-homicide statements. I know, and I won't, unless the state were to get up and say something different, there is a series of interviews and jail phone calls that the court knows because you've read my motion, but the response might indicate from the state that it's not their intent to attempt to admit that evidence.
They've described it as impermissible hearsay.
I will, bravo. And so to the extent that that doesn't, they don't change their mind or whatever from a tactical decision, decide that they want to try to enter it, I'll dispense with that argument. They do, in their response, and again, I'm not arguing the response, I want to save that for later, but as it relates to celebratory statements by Davion Murphy, what they, and the court has read them, they make specific reference to celebrating. This is after Foolio's murder on June 23rd, which is later in the day after those early morning hours, and we expect that they are going to enter those statements to celebrate Foolio's death. For the court's knowledge, the phone associated with Mr. Murphy, Rashad Murphy, was not located in Tampa by way of cell site information, by way of geo-tracking, by way of any forensic method. And essentially that phone, which is the fodder of many other motions, is shared by his girlfriend. The way that these things happen, and certainly just as an example of what I've talked about, is that law enforcement originally believed that those messages were sent by Rashad Murphy because why? He didn't have his phone, so he's using somebody else's phone. And certainly later, after corroboration from third-party witnesses, it was determined that that is not the case. And in fact, it was not Rashad Murphy that sent those messages. And I bring that to the court's attention because it is part and parcel about with what happens and what you can think and what you can believe and what you could be drawn to think if you're looking at things from an overview capacity. And I would talk about this in akin to a jury. So the next category of evidence, Judge, is gang affiliation. The central issue is going to be whether the state can establish the nature of the party's gang affiliation. None of the defendants admit to gang membership. There are no witnesses who will testify to personal knowledge of their purported affiliation. And that becomes important when we talk about case law and when we talk about other cases. Extremely important. Neither Andrews or Gathright are alleged to have any gang affiliation. As I stated earlier, defendant Chance was documented, that's another word in quotes, and certainly refers to statutory criteria, which, by the way, the jury needs to make that finding, okay? The state is going to put some detectives on, and they're going to talk about what they did, and I think, you know, we're going to talk about that in another motion, because I think that bears its own separate and complete argument. I'm digressing from Severance, but I think it's important in terms of context. And I don't want the court to feel that these individual segments of evidentiary issues that I'm bringing to the court's attention take away from the fact that Severance is different. The burden for Severance is different. So, again, Mr. Chance documented as ATK on March 8, 2024, 3 months prior to the alleged and charged offense. And I go through, I won't do it, the court can read it, you already have read it, read it again, that Mr. Chance is documented by law enforcement pursuant to statutory criteria, broadest criteria I think I might have read in any statute that's ever been passed by the legislature, but nonetheless, that's another story for another day. And it goes into those things that law enforcement use to designate or to document Mr. Chance. And those FIRs or those documentations are exhibits in the motion. It also talks about, again, I'd like to talk just briefly about the bully down poster that was found in Mr. Chance's house, constituting a diss or hatred toward Foolio. I anticipate, based on the depositions, based on the police reports, that the state's going to introduce evidence linking Mr. Chance to extensive gang activity. Activity that is associated directly with violent acts. Activity that, and listen, his counsel is going to have kind of the same arguments about how they go about getting that information. I'm just suggesting and telling the court, it's coming in, this is the way it's going to sound. This is the way it's going to sound if it comes in. And essentially, that Mr. Chance receives financial incentives for committing violent acts, that Ramos refers to Mr. Chance as the mastermind that handles the gang's war, that his Instagram handle is, I don't know, I think it's Rich Off War, and, or that may be his Cash App handle. So while the state alleges that Mr. Murphy is a documented 1200 member, the state's evidence as to that association is categorically different than it is as it relates to Mr. Chance. And it should be noted that it was a month after this homicide for which we were being prosecuted for that Mr. Murphy was designated as a gang member. I have set forth with particularity those instances under the gang statute that law enforcement used in order to designate document Mr. Murphy as a gang member. In an overall capacity, without getting into it ad nauseum, the court can read it, is these are unsubstantiated field interviews with random people being stopped for things as simple as possession of marijuana that they have no names, no dates, no person, don't do a supplement, don't do anything to memorialize that a stranger given a list of people. Hey, is so-and-so involved in the gang? So-and-so involved in the gang? So-and-so involved in the gang? Yeah, he is. Yeah, he is. Yeah, no, he's not. He is. That is the first part of documentation that is utilized in order to document Mr. Murphy as a gang member. And it goes into detail based on sworn testimony of detectives as to how they got that information. I question the detective about the specifics of what they say is a gang handshake that's seen given by Mr. Murphy, and he talks about a series of movements that come together, something that can be seen, but it's difficult to describe. And he goes on and says, I can't redo it. I asked him to do it with me. Can't do that. I don't know how to do that. Shows a video. I can't see anybody giving anybody a handshake. And essentially that is the second criteria by which Mr. Murphy is documented as a gang member. Thirdly, his association with Noah Williams, who is another individual who is documented as a gang member. He is purportedly, and in fact does, author or sing raps along the way as far back as 5 and 6 years ago, 2018, 2020, 2021, that are fodder and part of the state's attempt to admit into evidence in this case, that he is a gang member, but he is also a prominent musician. He is a person that has millions of views, that has signed a record deal with a national record company. So this is not a person who is simply just an alleged gang member, but a person who is an accomplished musician as well. He also happens to be a childhood friend of Rashad Murphy, known each other since they were small children. There is no physical evidence to link Rashad Murphy with any criminal gang, and no witnesses to testify to it firsthand. Importantly, I don't anticipate, at least I haven't seen any yet, evidence that would suggest that Mr. Murphy had any involvement in a gang war. So those are the categories of evidence which I anticipate that the court will run into, not only as it relates to the overview of this case, but also as the subject of other motions that have been filed, not only by me, but by co-counsel. Severance is required, Judge, under 3.152B1A. I strongly believe that this case illustrates why severance is required when the state's theory depends on inferential group narratives rather than individualized proof. The prejudice that requiring severance doesn't arise, like I talked about earlier, with one singular incident, but the cumulative effect of multiple categories of evidence that are admissible, if at all, against co-defendants. I do not believe that under the rules of severance, that is cured by inextricably intertwined or motive, either or both. It is going to cause the jury to infer motive or intent or participation by association with individuals that evidence admissible against them would be inadmissible against the defendant. Evidence linking Chance and Gathright to prior homicide of Foolio. Specific forensic and physical evidence seized from both of them that are unrelated to this particular charge and have no connection to the defendant, pre-conspiracy and post-offense statements that are attributed to co-defendants that may imply guilt or that may have to do with prior crimes and prior murders or attempted murders, celebratory statements made by co-defendants that initially were thought to be Mr. Murphy, but not, and extensive affiliation evidence that differs in scope depending on the defendant. Independently, they establish a substantial risk, Judge, that the jury's going to attribute co-defendant's conduct and motive to Mr. Murphy. Considered all together, they render a fair trial impossible, in my view. The risk that's demonstrated as it relates to 3.152B1A is, this is what it's designed to prevent. It's required when a joint trial threatens a fair determination of guilt or innocence, a fair determination of guilt or innocence. While the court has the discretion to grant severance when a jury could be confused or improperly influenced by evidence which applies to only one of the defendants, the court should grant, not discretionary, but should grant severance if the evidence directed at a co-defendant which is prejudicial to the defendant exists. I cite the court a number of cases that would establish this general principle. I'll get to it later. The state takes issues, especially with the McCrae state case that I cited, but it's not for the reasons that they say that I cited it. It's just simply for the standard law. The factual scenarios are different, and I don't say our factual scenarios are aligned. It's the premise and the context of the court's ruling that I want the court to take note of. I go on to provide the court with a federal court case, state versus Zaffro, excuse me, United States versus Zaffro, and Florida courts also have held that severance should be granted when the jury could be confused or influenced by evidence that applies only to one defendant. Again, cite McCrae, I cite the Hernandez case, and I cite the Cason case. The state has some aversion to the Hernandez case, and I'm going to talk about that in rebuttal, but essentially, I believe the Second District Court of Appeals agreed with me on that issue. And I think they agreed with my preposition as it relates to the context of this case. The danger of spillover in a circumstance like this with the litany of these defendants being tried together is magnified in complex multi-defendant prosecutions involving different degrees of culpability. And the courts talk about this all the time. The jury's asked to evaluate multiple defendants through a single narrative and a single framework, not inextricably intertwined, not motive. This is severance, and it's a different ballgame. I cite the Crum case, Judge, and essentially courts in Florida talk all the time about when severance turns on prejudice and not convenience. And certainly in this case, boy, that's a really big word. Because we all know, and we have spoke on numerous occasions about what would happen in the circumstance where the court grants this motion. And I don't suggest to the court for 1 second it wouldn't be a nightmare, but I believe it's necessary. The courts reject severance, Judge, if the following factors are present, none of which are present in this case. There's substantial overlapping evidence applicable to all defendants, not here. And that's citing the Forbes case. Joint trial is proper where evidence of conspiracy, phone records, DNA, and eyewitness testimony applied collectively to the defendants. None of that exists here. In those cases, by the way, Judge, those evidentiary issues, by the way, are determined by witnesses, by live witnesses, by people that take the stand, and people that testify to those things. Independent evidence establishing each defendant's guilt. I cite the Hunter case, which the state has an issue with, and I'm going to talk about that in rebuttal, that severance is required when defendants' own admissions, not here, physical evidence, not here, and co-conspirator testimony independently establish guilt. And then, of course, other crimes that are, that evidence is linked to the defendant. In the Castillo case, no severance required when the predicate racketeering acts, though numerous, were tied to the defendant's leadership role. And then, of course, antagonistic defenses, which I've already suggested to the court, is not our argument here. By contrast, Judge, the court has held that severance is required when the following factors exist. Each, which is present in this case. Evidence admissible against a co-defendant, but inadmissible against the defendant. And that is buttressed by the Second District DCA case of Hernandez versus State at 572nd 404. And the DCA there reversed a denial of severance where prior drug transactions, this happened to be a brother who lived with the co-defendant.
And this all cropped up mid-trial in front of Judge Graybill.
Yep, sure did. Lost my place.
What's okay? There were
And
two
applied only
brothers.
to the brother and
There were
not to the
two brothers,
co-defendant.
co-defendants. They were both accused of trafficking and conspiracy to traffic cocaine. And then in the middle of the trial, evidence came up as to one brother and other prior drug transactions that the co-defendant brother had nothing to do with. And
Could happen here. Probably will happen here. Could happen here by co-defendant testimony. Could happen here by cross-examination of counsel that might open the door to a number of different things. But at that stage of the game, what the court said is that obviously where those prior drug transactions applied only to the brother, that severance should have been granted. Also, Judge, the second type of case where severance is required is the expansion of admissible evidence through co-defendant's conduct. I cite Dix, where they suggest that severance was required where the co-defendant's statements were used to support the state's theory of guilt, but would have been admissible as to the defendant. Again, a brutal issue. But thirdly, the risk that the jury will infer participation based on association, and that's back to Hernandez again. This is not a routine joint trial involving overlapping of independent proof tying each defendant to this case. As to Mr. Murphy, there's no forensic or ballistic evidence. There's no admissions or inculpatory statements. There's no animus directly toward Foolio. There's no participation in any prior violent offense. I will suggest to you that the state may indicate that, again, I'm talking about facts, I'm talking about admissible or inadmissible evidence, that in 2018, 6 years before this case or this murder occurred, that an individual by the name of Joe Rod Adams was killed, okay? And in fact, Mr. Murphy had a connection to Joe Rod Adams. They would suggest that's his brother. It's not his brother. People call each other brothers. They're not brothers. But I think that's what the state might suggest to you. Number one, it happened 6 years before this. Number two, Mr. Murphy's not involved in any violent act that I'm aware of or that even detectives will testify to in speculation or opinion. And certainly no one will walk in here and tell you or tell the jury that that exists. So to that extent,
Mr. Gonzalez, before Mr. Sonardi needs to leave, I just want to, if he's got anything to add, you said 2:30, correct?
Correct, Judge. Our position is very similar to that of Mr. Rashad Murphy as it is to Davion Murphy. It dovetails the same arguments and factual basis. So
Okay.
we would adopt it on
Okay.
behalf of Mr. Davion Murphy.
All right, thank you, Mr. Sinerdi.
May I be excused, Your
Yes,
Honor?
you may.
Thank you.
Judge, instead of the defense anticipates that the state is going to rely on surveillance-based inferences, primarily, number one, the comparison of the defendant's clothing, all black, back boots, back jeans, back shirt, black hoodie, that he is seen wearing in a Walmart with surveillance video 36 hours before the murder in another jurisdiction, with pictures taken of shooter number one at the scene of the crime, where that individual is dressed in all black. Just for context, I don't know if this is working, Judge, so just for context, there's Mr. Murphy in Walmart, and there is the picture of the shooter at the scene. And this primarily, as it relates to surveillance-type inferences, is going to be the state's evidence as to the fact that shooter number one is Rashad Murphy. That would also be in addition to Mr. Murphy's presence in Tampa after the murder took place. Hours after the murder took place, Mr. Murphy, there's going to be evidence that he was in Tampa in the company of some of the other co-defendants in this case. Not all of them, some of them. And an inference that the state's going to make that he drove down with them from Jacksonville, which there's no evidence to suggest he did. Number two, that he was in the Airbnb that the court's aware of, although he's not on any surveillance video going in and out of the Airbnb, and speculating that he must have gone in through other means in order to get in. Judge, evidence of the prior attempted homicide of Julio Foolio is admissible.
Why don't we refer to him as Mr. Jones?
I'm sorry, Judge?
Let's refer to him as Mr. Jones.
So much easier, Judge. I forget
I
Jones,
know,
Jones,
I
Jones, but I always
understand, I know.
remember Foolio.
Yes.
Yes, Judge, I'll do my best. So the attempted homicide of Mr. Jones, the state's most compelling evidence with regard to that attempted murder concerns the actions of other co-defendants' involvement in that attempted murder, and there's no comparable evidence as it relates to the defendant. All of the evidence as it relates to that incident is with reference to other co-defendants, and it precedes the conspiratorial time frame by a year. While the defendant, Mr. Murphy, doesn't concede that any evidence related to that murder is admissible, evidence to establish a shooting that occurred is categorically different to evidence directly linking co-defendants to that act. And that's what happens when we sit at this table, without question, and I think without there being any other way but spillover. Mr. Murphy, has no evidentiary involvement in that case, and others do, not only by statements, but by forensic evidence. This distinction, Judge, is really critical. If the state's permitted to establish that Mr. Jones' attempted murder is itself retaliatory, basically, as it relates to detectives' perceptions and opinion evidence, as it relates to Tilley's homicide, retaliatory in that respect, then the state's no longer offering the incident merely as background or context, which is what it should be meant to do. It's establishing co-defendants' direct involvement in an ongoing cycle of retaliatory gang violence that Mr. Murphy is not subject to. Once that showing is made, the scope of this evidence expands dramatically. It opens the door potentially to testimony and argument concerning those prior acts, whether it be, again, like I said, in cross-examination or testified by jointly tried defendants. Doesn't matter that Mr. Murphy would have a right to confrontation. That's not what I'm saying. What I'm saying is that it is heard, perceived, and taken in by the jury to begin with. Most of the prior acts, I believe in another motion, the court will see that I broke it out in a chart. I think 9 of the 13 acts are unsolved. The gang retaliation is largely, if not entirely, predicated on law enforcement opinion testimony that is drawn from a variety of sources. Lyrics that they are interpreting from songs, social media posts that they are interpreting over years as it relates to this crime in June of 2024 and long outside the conspiratorial time frame. But the state's evidence of co-defendants' direct involvement in certain cycles of this violence bolsters the state's case as it relates to Gathright and Chance. Certainly not as it relates to Mr. Murphy. The expanded narrative might be admissible against Chance and Gathright in the event that the court rules unfavorably on motions that are pending before the court, but it's inadmissible as it relates to Mr. Murphy. I go on to talk again about, at length, the Hernandez case, which we already touched upon. And the Hernandez case quotes Crum, which is a Florida Supreme Court case. The objective of fairly determining a defendant's innocence or guilt should have priority over other relevant considerations such as expense, efficiency, and convenience. The prejudice of this particular case, Judge, is even more acute. Unlike Hernandez, the collateral evidence that just involves some drug activity that was unrelated to the charged offense, as the court pointed out in the factual basis you're aware of, the evidence at issue here concerns an attempted homicide against our victim a year earlier, offered to establish an underlying motive, in a conspiracy prosecution predicated on group motive and collective animus, presenting evidence that is directly linked to co-defendants to that prior attempt of the same victim creates an inescapable risk that the jury will attribute that participation to anybody else sitting there. I just can't imagine. The court might say, well, every jury's different, and certainly they're asked to compartmentalize, and they're asked to consider the evidence only as to one person and not the other, and that's all great, but it shouldn't be done. I don't believe the case law allows it to be done in this particular case, and I don't believe that limiting instructions, I don't believe that any instruction would keep it from happening. I think association alone will rule the day. Because nothing can distinguish between an individual's retaliation and a group's retaliation or other individuals other than the defendant's retaliation. Severance is required to prevent the jury from conflating evidence of co-defendants' conducts, and that's what's happening here. The next category that we're talking about is co-defendant only physical evidence inadmissible as to Mr. Murphy. We talked about those things, and in general, there's no forensic evidentiary nexus to the defendant that would be inadmissible against him in a separate trial. And so in a separate trial, none of the forensic evidence comes in. None of it. And to that extent, I believe that requires severance. Thirdly, Judge, statements again, that we talked about that are attributable to Chance, to Davion Murphy, to Gathright are also inadmissible as it relates to the defendant. And I cite cases for that proposition. And also as it relates to statements that are made, and court talked about this earlier, statements versus physical evidence under 803.18e, that they were made either prior to or after the alleged conspiracy and wouldn't qualify for admission. Importantly, while the evidence might be admissible against those people, those individuals, respectively, those statements were not made in furtherance of a conspiracy, and they're inadmissible as it relates to Mr. Murphy. Finally, Judge, the gang affiliation evidence and the propensity for association. The evidence offered against Mr. Murphy is speculative in totality. It's derived from undocumented informants or individuals off the street. It's derived as it relates to interpretations and association with known people that are not involved in gang activity at the time. And critically, in contrast to some of the other co-defendants, there's no evidence linking the defendant to ongoing gang activity in the form of crimes, in the form of violent behavior, in the form of prior murders or attempted murders, aggravated assaults, shooting into vehicles. Doesn't exist as it relates to Mr. Murphy. We recognize, Judge, that while evidence of gang membership may be admissible on the issue of motive and intent, specific evidence associated with a co-defendant's gang membership, in this particular case, evidence being entered on a speculative basis by law enforcement officers, not by individual witnesses who have direct knowledge, is not relevant to Mr. Murphy. I'm going to talk about later on Richardson versus State and talk about recognizing the admissibility of evidence of gang membership on issues of motive and intent. The state's theory is not that the individual defendants had a specific motive to kill Foolio, but rather that they acted in conformity with their affiliated groups. And gang rivalries is not a gang rivalry between a defendant, and in this case, Mr. Murphy and Foolio. It's a gang rivalry between gangs. And to that extent, I think that's what sets it apart. And we're going to talk about Richardson because the court may or may not have recognized by now, when we talk about the Robinson and the Hayes and the Richardson cases, they are Duval County cases. They are related to this case, at least to the extent that the state would suggest they are inextricably intertwined. And I believe the state's going to cite them as a reason for admission of that evidence. And I think when I make my argument, I think the court's going to recognize that that's not what happened. And those cases are far different than this case. I digress because we're not talking about admissibility of evidence, we're talking about severance. But it's hard when you're laying out an argument like this and you're seeing this boatload of factual evidence dump into this motion for severance that I think is a circular argument. And I think the state's attempt, and I don't mean it in some unethical manner, but their attempt to flood this motion with all these factual statements is not what the court needs to consider when it relates to severance. What I will tell the court, though, is that their reliance on some of these cases, even though ironically they have the same underlying retaliatory historical basis that this case is alleged to have, I think the findings and the rulings of those courts are enlightening as it relates to that. As I said earlier, Judge, and I'm getting to the end, even a seasoned detective, and I don't mean Jacksonville gang detectives, although they are detectives and they've worked their job, you can see in the other motion what their historical training and experience is. I've set that forth with particularity in one of the other motions. We have a homicide detective here in Tampa who handled the investigation. The court's aware of Detective Ramos. Even Detective Ramos, during the course of this investigation, made some investigative errors that he ultimately corrected himself and ultimately said, no, what I thought might have been the situation turned out not to be so. And to his credit, he made those observations both in his reports and under oath. And I bring this to the court's attention because I think that it's inconceivable that jurors are held to a higher standard than law enforcement might be and are capable of disregarding compelling evidence that is attributable to one defendant and not the other. And if this court limited the scope of admissible evidence, there's no feasible manner to ensure that other parties might not open the door to otherwise inadmissible evidence during testimony or during cross-examination. And we have to respect and understand and make our decisions, in my humble opinion, based on those factors as well. Because again, what we are looking at is what allows Mr. Murphy to have a fair determination and not be prejudiced by evidence that would otherwise be inadmissible to him. I have suggested to the court that if you are not convinced that severance is proper, that we need to have separate juries. And although I don't think that's a cure, and I think I might be the only person, and I could be wrong, that tried a case in Hillsborough County with 3 juries. I know there's been many, many times that there have been 2 juries. I tried a case with 3 juries.
Is that Cas Castillo's case?
Yes, Judge. I had one of the co-defendants in that case. Judge Fuente had one as well, and Mr. Castillo prosecuted that case. Nightmare.com. And certainly, very fortunate, I will say, the court's probably going to say, well, it didn't come back on that issue, and it didn't, but it was a miracle, and it probably could have or should have. But in that light, the bottom line is that I can only anticipate amplifying that by another one.
Well, didn't you have Bruton issues in that one?
We did. It wasn't as much the reason for the separate juries that I was referring to. It was more just the logistics and the fact that it occurred, and to the extent that there's not a problem. And I know the court has said, and I have no reason to disbelieve the court. If we had to, and that's what I choose to do, we'll find a way to make it happen. And I'm not suggesting the court can't do that. I'm just suggesting that it brings ripeness to the inevitability that something could go wrong in the very slightest of circumstances, much less something more magnanimous. So that is obviously the fallback position. Finally, Judge, guilt phase instructions don't cure penalty phase prejudice. I point out to the court in the motion that in the guilt phase, 3.12c instructs the jury about how to consider evidence independently with regard to co-defendants. Certainly not a cure-all by any stretch of the imagination, but there is an instruction that references what the law tells the jury to do. No comparable safeguard exists in penalty phase instructions. To the contrary, the instruction directs jurors to engage in a holistic, qualitative weighing process. They've now heard varying amounts of evidence against varying defendants in the guilt phase, so you have to ask them to sanitize themselves and continue to compartmentalize in that particular circumstance, which presumably and hopefully they do in a guilt phase. And then in a penalty phase, the process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare the number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance against A, B, C, D. Some, presumably defendants, in the event that there's an adverse verdict, may have much more mitigation than other defendants. Although the aggravators are similar in nature on paper, they are not similar in nature as to, let's say, what the prior felonies are, what a person's individual prior makeup, prior history, whether it be familiar, whether it be intellectual, whether it be school-wise, whether it be psychological. To ask a jury to deliberate in this fashion as it relates to the lives of these four individual defendants is, in my estimation, too much. I think it is fraught with an inability to continue to compartmentalize not what is evidence as to their guilt, but those factors that would be needed to determine whether someone should be put to death.
But isn't that what happened in the Hunter case? Right? Hunter had multiple co-defendants, right? The state was seeking death as to all three?
Yes,
Right.
Judge?
So it's not unheard of.
Not unheard of.
Okay.
Not saying it's never been done. Saying it's fraught with problems, and certainly, now, and of course, we have an additional, certainly everything that happens in multipliers changes likelihoods, in my opinion, but the court's correct in that regard. Don't consider that co-defendant's extremely lengthy and historical violent criminal behavior. Don't consider that. Don't think about it. They've just been convicted as a group. They've just been certainly, and again, we're talking about evidentiary issues that are not ripe yet because the court hasn't ruled. Acts that certain people committed during the course of a potential conspiracy that others didn't. Although the law might suggest that if it happens during the conspiratorial time frame, it should be considered against all of them. Let's separate that now when we're talking about whether someone should live or someone should die, and continue to hope that all of now this emotional type evidence that's going to be submitted can be weighed properly. Judge, I'm not going to take any more of the court's time on the perils of the penalty phase deliberations. I have set it forth with a little bit more particularity in the motion, and it stands on its own. There are some cases cited, Judge. Although the court has discretion to order separate juries to avoid severance, doing so will result in significant practical difficulties. Florida courts have emphasized that, I'm going to say it without even looking at you, must take great care to ensure that each jury hears evidence relevant only to its defendant. And that's as it relates certainly to multiple juries. There are cases that are cited that stand for that proposition. At the end of the day, Judge, this is not a routine joint trial with overlapping proof. The state's most compelling evidence is directed at co-defendants, and it invites guilt by association. There are several different categories of inadmissible evidence, co-defendant evidence, that I believe is inadmissible as it relates to Mr. Murphy. And a group narrative in this case is clearly a concern. And severance is required under the rule, or alternatively separate jury panels, when the defendant's constitutional right to an individualized determination at both phases is not afforded.
Mr. Gonzalez.
I would love to talk about the evidence as suggested by the state and its propriety and its weight.
Let's not.
And its defensibility.
It's
But
not. Listen,
nonetheless,
that's why we have juries.
as I stated in the beginning, Judge, that's not where we're at. What I can and what I would like to talk about is, again, inextricably intertwined. It's a word that's used
I know, but we're
often.
getting, and that's fine, but we have a whole separate motion dealing with what's gonna be admissible. And I feel like at this juncture, we should kind of hold that in abeyance until I've made my ruling on what's gonna be admissible with regards to the gang history coming in. So,
Well, let me then, Judge, you've heard my argument as relates to the severance. I, quite frankly, am glad that the state would like the court to be hyper-vigilant in wrapping its arms around the Richardson case. Because the Richardson case is not this case. It's so far from this case, other than the fact that it has similarities in players, similarities in historical
jurisdiction,
similarity in some of the things that the state has alleged are, again, inextricably intertwined. But let me first say that Richardson doesn't end with Richardson. It's Richardson and Hayes. And you know what happened with Richardson and Hayes? They got severed. And so the first thing is that this murder took place and co-defendant Richardson and Hayes were together. It was unfortunately a drive-by shooting where a child was killed.
and Mr. Gonzalez, I'm not trying to cut you off, I'm really not, but I feel like that discussion, at this point, what I want to hear from you, all right, is what would be the evidence that the state is seeking to admit that would be inadmissible as to your client if he were to go to trial alone?
Judge, what I want to tell the court is that if the state is relying on Richardson to tell the court that this inextricably intertwined evidence should not create a severance, because that's what the Richardson court said, you need to understand that this evidence there were individuals, 4 or 5 of them, that testified, okay, to that inextricably intertwined evidence. They testified, they had live witnesses that said, I was with him when he did this. I was there when he had this gun. I was there and I was a member of the gang and he was a member of the gang. Again, the reliance upon the state's case here is squarely in the hands of law enforcement. Richardson and, of course, Hayes, in his severed trial, all had direct evidence being provided to the jury by individuals who were corroborating the evidence against Richardson and against Hayes. I would tell the court that if you read Hayes closely, and I really think that you need to,
I have.
when it comes down to the issue of severance, okay, it is completely 180 from what the state's evidence is and what the state's arguments are for severance in this case, or the lack of it.
Okay.
So I would tell the court, again, I don't believe that any of the evidence found as it relates to the search warrant of Gathright's house, the vehicle of Gathright, the search of Chance's house, the interactions with Chance, whether it be by Instagram, whether it be with Ms. Andrews, whether it be to third parties, about his involvement in this and any other violent crime, as it relates to, again, as the courts noted, the celebratory issues, as it relates to vehicles that came down from Jacksonville that the state has no evidence that Mr. Murphy was in, vehicles that left Tampa to go their various directions. Nobody left out of the same parking lot. They didn't leave together. I think that fundamentally,
So your position is that if your client went to trial by himself, none of that evidence would be admissible?
no, it would not. I believe that. No, I believe that, I believe it's not part of any conspiracy. It's not part of any actions by a principal. And of course, I'd have my arguments as to both of those things on another day at another time. But essentially, again, the gang affiliation evidence.
Okay, but
that
I understand, listen, I do need to give the others a chance to argue
Yes,
their
Judge.
motions, and I didn't give you guys time limits, I may start giving you.
Yes, Judge, I understand.
But, would you agree with me that if I make the determination, which you will disagree with, but if I make the determination that there is evidence regarding the previous history between these gangs, that it is inextricably intertwined as it relates to all four of the co-defendants, then there is not a basis to sever as to that issue. Do you at least agree legally, based upon the case law? You may not agree with my decision, but do you agree that's the posture that we would be in regarding severance?
Based on what issue?
On the inextricably intertwined evidence, the history or the pre-events, not the
Oh, well-
homicide, but the
Well, if the
history
court,
of the
if the court,
gangs.
if the court lets it in, then I would suggest that, that issue then would not be an issue for severance if the court lets it in. I mean, if the court lets it in, I would certainly take issue with that court, with the court's ruling.
Right.
Because I don't think it should be admitted as to Mr. Murphy based on the totality of circumstances.
Okay.
But that would certainly just be, one prong of what I believe severance is buttressed on. And, and that certainly would be evidence of prior acts, and I don't mean just gang violence. I mean just acts that Mr. Chance might have allegedly been involved with that the state's gonna try to introduce, as it relates to statements that he made at various different points in time. I believe that the forensic and the physical evidence is another reason why severance should be granted as it relates to Mr. Murphy. All of those, again, we've talked about post-fatality or post-homicide statements. That would create a basis for the severance, as I've argued. And then finally, Judge, and certainly not least in any way, shape, or form, would be the culmination and the cumulative evidence of the prior history.
Okay. All right, thank you, Mr. Gonzalez. All right, who wants to go next? Mr. Counsel for Mr. Chance or Mr. Gathright? Do you guys have a preference?
I can go, Your Honor.
Okay, very good.
Going down the table.
Sure.
So, Your Honor, I'd just like to adopt all of Mr. Gonzalez's very eloquent arguments, and for the sake of time, not go back over those. I would point out, Your Honor, I recognize, of course, severance would not be convenient, it would not be efficient, but this system is not designed to be efficient or quick, it's designed to be fair and just. And I think the only way any of these defendants are gonna get a fair trial in this case is to be tried separately.
And do you agree there's no Bruton problem as it relates to your client?
I do agree, but that's only part of the analysis, Your Honor. I think the rule is if it's appropriate to promote fair determination of guilt or innocence. And one quote I put in our motion is that it's from the Menendez case from the Florida Supreme Court many years ago. Severance should be granted liberally whenever potential prejudice is likely to arise. And I think we just got a little glimpse of the potential prejudice that's likely to arise in this case. I started to quote one of the things Mr. Gonzalez said early on, talking about the search of Mr. Gathright's car, that there were a litany of firearms, magazines, ammunition, yada, 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 found. And we heard many, many times about what's found in Mr. Gathright's car. And I'm not suggesting Mr. Gonzalez by any means is doing anything inappropriate. He's effectively advocating for his client.
Correct.
But in doing so, he's now essentially implicating Mr. Gathright.
I know, but
And
didn't, the courts have said that's not enough to get you a severance.
Well-
Just because you're pointing fingers at each other, that's not enough.
Well, I think it's a case-by-case basis.
Correct?
And I think that it really depends on each individual case and the circumstances. And we have four, I would suggest, very differently situated defendants. And one thing I would point out as well, Mr. Gathright's name never, from what I can tell, ever surfaced in connection with that prior shooting of Mr. Jones until the casings were found. So it's not like, he's being investigated by Jacksonville. I was going to mention in a moment, but none of these Jacksonville deputies even knew who he was.
Right.
Until Tampa contacts them. But now, obviously, as we see, Mr. Gonzalez is going to be bringing up, as he rightly should, that his client has nothing to do with this other investigation. And that really brings up an issue that's probably individual to Mr. Gathright, because he's a little differently situated in that he has no connection at all to this gang. We took a week's worth of depositions of Jacksonville officers, I believe they're all detectives, and at least a couple of them are designated as gang experts. None of them knew Mr. Gathright or even heard his name, as I recall, until TPD contacts them in connection with this. There's no evidence that he was part of this gang. The state has not alleged that aggravator as to him. And in all candor, I'm going to argue at every opportunity that he's not part of the gang. But the risk we run, number one, that I think raises issues for the other defendants, but the other risk we run, like the Hernandez issue, is that, and I took a quote from Hernandez, but I believe that the issue they were concerned about was that the jury, when they're looking at the prior acts of the brother that come in against the co-defendant, the jury certainly could have attributed to Hernandez as a possible participant in these acts, and that may have contributed to the verdicts of guilt. That's what I'm concerned about here, is that they're going to hear, and I believe it's frankly going to be a feature of the trial, the gang connections and the drill rap videos that Mr. Gathright has nothing to do with. They're just going to assume, well, he must have been in this gang. He must have taken part in all these alleged prior acts. And if he were tried separately, maybe there'd be some evidence of the gang connection. Frankly, I would probably want some of the evidence to come in. Because again, he's not part of that. And that is the motive for this whole alleged homicide. But the problem in the joint trial, I think, is it's going to become a feature. We're going to see all these drill rap videos, I expect. We're going to hear from gang experts about this gang. The jury is going to have to compartmentalize that, hopefully see that he's not a member, but the risk, like the court was concerned about in Hernandez, is that they're going to just assume, well, he must be, because we've heard all this evidence. We've heard about all these prior acts. It was, frankly, a feature of the trial. He must have been part of it and just never got caught. That's the concern we really have, I think, at the heart of it. As to individual pieces of evidence, Your Honor, I think one that you pointed out are these post-homicide text messages. I don't believe those
I've
would
already
be
pretty
admissible.
much ruled on that one.
Yes, Your Honor, I agree. There's another one that really, I think, has just kind of recently come up, and it's not mentioned in the response to Mr. Gathright's motion to sever, but it is in Rashad Murphy's response, that apparently on the morning of October 7th, 2023, there's that's when I believe the first shooting of Mr. Jones occurred, or shortly after, but it states in there that there's a recorded video chat conversation that occurred on Spaces video chat room on X on June 6th, in which co-defendant Isaiah Chance asked the victim, "Hey, Foolio, your foot okay, cuh?" and stating he has bigger fish to fry. And then this is apparently the Spaces chat, which is something I was not familiar with, is public. And then it states that on June 6th, co-defendant Chance and Victim Jones continued to argue back and forth on the social media platform. And then Rashad Murphy texts co-defendant Sean Gathright. It states, Gathright and Chance are best friends, and Murphy instructs Gathright to make sure that Chance doesn't ruin the plan, letting him get worked up because they've got bigger things to tend to. So I have been through the iCloud dump for many, many hours, and I'd never seen that. And it never came up that I saw during the 2 days of Detective Ramos's deposition. But in any event, I'm pretty confident that Mr. Gathright, if that was sent to him, did not respond back to that. So now we have another instance of something that apparently Rashad Murphy allegedly texted him that I don't believe would be admissible in a separate trial, and frankly could be viewed as pretty damaging evidence to the jury. That I don't see how it comes in unless there's a context or a foundation established for a co-conspirator admission, but without any response from Mr. Gathright, I see no basis for it. I don't know if that's something the state's intending to admit, and quite frankly, I had never seen that until yesterday when Mr. Gonzalez called me frantically and mentioned it.
And so you referenced in the state's response, what page? Do you know?
Not in Mr.Gathright's response. It's
Right.
in the response to
Rashad
Rashad Murphy on
Murphy.
page
What-
5.
Okay, let me just
and
take a look.
Sub F on page 5.
Okay, I see it.
So that, again, Your Honor, when you're asking for individual examples, that's one that is particularly concerning to me, and I don't believe would be admissible if Mr. Gathright were tried individually, especially if there's no response, which I don't believe there is. And then last, Your Honor, just to kind of highlight again, this isn't the typical case because this is a death penalty case, and we're basically going to have 2 trials for each defendant in this case. Not only do they have a right to a fair determination of guilt, but they have a right to an individualized sentencing determination. And as Your Honor pointed out, there have been Florida Supreme Court cases that have found that it was not error when some co-defendants were tried separately in death penalty cases. But again, I think it's a case-by-case determination. And here we have 4 defendants on trial. There's going to be very different, I believe, aggravating circumstances that issue. The probably most significant one is the gang aggravator that, again, is not alleged as to Mr. Gathright, but I believe is alleged as to the other 3 defendants. We're going to have to hope that the jury, again, can compartmentalize that and not assume that it must apply to Mr. Gathright as well, which I think is a very dangerous thing to presume, especially when we're talking not just 2, not 3, but 4 defendants in this particular situation. And the other difficulty that I see that I don't really know if cases have addressed, but we don't really know what other defendants are going to present for mitigation. We don't know how the jury is going to compare each defendant. I believe there's a plethora of mitigation as to Mr. Gathright, but I don't know what we're going to hear about other defendants or how the jurors are going to potentially weigh that if they're being asked to decide the sentence as to each individual defendant, and potentially not just weigh aggravators from the state and mitigators from the defendants, but potentially weigh the mitigating factors that each defendant presents in comparison to one another. So for all of those reasons, Your Honor, I think that it's a very dangerous situation if this case is to go forward as a joint trial. And I think the only fair way to ensure a fair and just determination of each individual defendant's, not just guilt or innocence, but if we get to penalty phase, the appropriate sentence is to try them individually.
Brief, because you've heard mostly everything, and I'll adopt Mr. Wise and Mr. Gonzalez's motion, and I'm sure the court's read my motion. A couple things I wanted to bring up. You talked about the McCrae case and improperly influencing, and that's one of the issues we would have, and some of the items that I believe that would not be admissible against Mr. Chance. You talked about Davion Murphy's statements. We would also bring up the casing found in Mr. Gathright's car that links to the 10-7 attempted murder of Mr. Jones. There's no link to Mr. Chance in that, other than rumor and the attempted murder happened in close proximity to allegedly someone that Mr. Jones used to date. And that's the only connection. The casing has no connection to Mr. Chance himself, as well as anything found in the search warrants of Mr. Gathright's home. We would also argue that any aggravators that will be heard outside of CCP would not be applicable to Mr. Chance as well, including gang aggravators, because there's different gangs involved here, so that the jury would hear different gang aggravators and that don't involve ATK. Further, Mr. Chance is not in any of the drill rap videos. His name is not mentioned. Mr. Jones does not ever diss Mr. Chance in any of the drill rap videos. He doesn't diss Tilly in any of the drill rap videos. So we would argue that any of those videos should not be admissible against Mr. Chance because they do not provide motive to Mr. Chance specifically. He's not mentioned, he's not in them. And I know you want to get into this later, but any mention of 1200 or bully gang, we would argue is applicable, not admissible, and is prejudicial against Mr. Chance, as he is well, the state's going to try to attempt to prove that he's a documented member of ATK, but only ATK. So we would argue that any mention of 1200 as proof of motive, or bully gang, which is a alleged subset but not a member of 6 Block, would be inadmissible against Mr. Chance. And we would also argue that all that would end up becoming a feature of the trial, as Mr. Wise said. All the prior inextricably intertwined stuff, which I know we'll get to a different day, and it will be impossible for the jury to put that aside, especially when we're talking about, again, gang that even the state would admit that Mr. Chance is not a member of, which would be 1200. And as Mr. Gonzalez stated, a lot of these prior murders are unsolved. And while the state may bring in witnesses from law enforcement to talk about the specifics of those murders, those witnesses will have no idea who committed those murders because the state and detectives up in Jacksonville still have no idea who committed these murders. So based on that, and based on what I've written in my motion and what you've heard here today, we believe that a severance of Mr. Chance's case from his other co-defendants is appropriate and necessary in this case.
Okay, very good, thank you.